Good afternoon, everyone. The hour having reached 3 o'clock Eastern time, I'd like to welcome all of you to our June 9th, 2026 public briefing. We're the New Jersey Advisory Committee to the U.S. Commission on Civil Rights. I'm Robert George, McCormick Professor of Jurisprudence at Princeton, but here today in my role as chairman of the committee. Before we get started, I'd like to remind everyone that this meeting is being recorded. My first duty is to take the roll, which I will do right now. Robert George, chair, is here. Daniel DiMartino.
Present.
Daniel is here. Kevin Jackson.
Present.
Kevin is here. Erica Jelinek.
Present.
Erica is here. Our colleague Nathan Link is excused today. John Londrigan.
I am here.
John is our secretary and he is here. Chanel Portia Albert. Chanel has not joined us yet. Glenn Ricketts.
Present.
Glenn is here. Our vice chairman, Miranda Jane Sapphire. Miranda Jane.
Here.
Jane is here. Salo Santiago. Salo is not here yet. The U.S. Commission on Civil Rights is an independent, bipartisan agency of the federal government charged with studying discrimination or denial of equal protection of the laws. In all 50 states and the District of Columbia and the U.S. territories, an advisory committee to the commission has been established. We are the New Jersey Committee. And the committees are made up of responsible people who serve without compensation to advise the commission on relevant information concerning their respective jurisdictions. Today will be the first time that we, as the New Jersey Committee, receive testimony on the topic we have selected for our project, which is the topic of anti-Semitism. Our focus today will be on definitions of anti-Semitism and their relationship to civil liberties concerns. And we have two very distinguished guests with expertise in this area from whom we will learn. Our committee is interested in learning about the resurgence of anti-Semitism that we see all over the country. And of course, we're most interested in what can be done in a way respectful of basic civil liberties to prevent or mitigate this phenomenon, especially here in New Jersey. Our study is not focused on Middle East politics or the Israeli-Palestinian conflict. We have no jurisdiction to delve into those matters, nor does the U.S. Commission on Civil Rights. If any remarks shared today are outside the intended scope of this study, I, as chair, am obligated to redirect the discussion. On to the event format. Today, we will hear from those two distinguished panelists I mentioned. Each will speak for 12 minutes. At the 2-minute point, at the point at which 2 minutes are left, I'll give the what in basketball is called the 2-minute warning, or in football, and then announce when the time has ended. After each of our panelists has made a presentation, we'll begin the Q&A session between the panelists and members of the committee. I will use the roll call list to give committee members a chance to speak. Each committee member will have up to 5 minutes for their questions, and that time will include the time taken by the panelists to answer the questions. A timer will be used to indicate the time remaining for each committee member. Members may submit any personal statements they would like to include in the record. To do that, they'll do it in writing to our Civil Rights Commission representatives, or DFO. Members may yield time to other members at their discretion. Committee members may also submit supplemental materials such as articles, reports, legal analyses, or news items. They can be included in the record and will be helpful to us. These materials must be referenced during today's public briefing and submitted in full, both to me as chairman and to our DFO, that means designated federal officer, within 7 days. That means by June 16th. As time allows, I'll circle back for a second round of questioning, or I should say, if time allows. That round will not be timed. Committee members are asked to focus on a question and not to share comments or their own opinions on the topic. They can do that by the written submissions. Now, after the Q&A session between the panelists and the committee members, members of the public will have up to 2 minutes each for comments. Members of the public should kindly note that the public comment section is intended for remarks on our study and is not meant to be a Q&A session with committee members or panelists. You are not to ask questions to or engage in debate with either our guests or the committee members. And a timer will be used to notify people when their time is up. I, as chairman, of course, reserve the right to provide warnings if any speaker on the call is over time and ask the staff to mute them. I hope I won't have to do that. We ask that everyone respect the time allotted and end their remarks within the allotted time. The U.S. Commission on Civil Rights asked me to say that though some of the statements made today may be, and I'm sure will be, controversial, we want to ensure that all guests today do not defame or degrade any person or organization. If a specific person or organization is named in a potentially defamatory manner, they will be provided an opportunity to respond, and this response will become part of the record. As the chair, I again reserve the privilege to cut short any statements that defame, degrade, or do not pertain to the issue at hand. Shift us to some question other than what is the question before the House having to do with anti-Semitism and civil liberties. Based on our proceedings, our committee will prepare a final report which will go to the U.S. Commission on Civil Rights, and our report will detail the findings and our recommendations for addressing the issue of anti-Semitism, again, especially in the state of New Jersey, but we all recognize, I think, that this is an issue of national importance and indeed of some urgency. That draft will be available for public review, and we're grateful, of course, to all speakers for their willingness to share their thoughts and experiences with us today. Now, at the outset, I need to remind everyone of the ground rules. This is a public meeting, and remarks will be recorded and transcribed for the public record. Please bear that in mind. Nothing can be private. This is a public record meeting. We will adhere to the agenda to ensure we cover all the necessary materials within the limited time available. After hearing from all the panelists today, committee members will be called on by me as chair using the roll call list. After everyone has had a chance to ask a question, and if time allows, I may ask if anyone has additional questions. Committee members are asked to use the raise hand function in the Zoom to express their interest in asking a question. I'll call on committee members in the order that their hand was raised. And here I need to ask Victoria and Evelyn from the commission to please let me know if I'm failing to see a hand that's up. I don't see all of our committee members on the screen at one time. I have to move back and forth. So please, Victoria and Evelyn, if I'm missing a hand that's up, I don't mean to do that. So please just make sure that I know that there's someone who needs to be recognized. To accommodate persons not on the agenda but wishing to make comments, we'll ask for a public comment at the end of today's meeting. I'll first call on any speakers who submitted public comments sign-up forms in advance of the briefing. They'll get first priority, and then if anyone else would like to make a comment as time allows, I'll ask you to raise your hand in Zoom, and I'll call on you in the order in which I or our staff see you. The raise hand function can be found by clicking on the reactions icon. Again, the reactions icon, that's where you find the raised hand function, and that's at the bottom of your Zoom screen. You'll be unmuted by the staff at that time so that you can speak. And again, 2 minutes will be allowed per speaker. Again, we have to remind everyone, these are comments. They're not meant to be questions or discussion with our panelists or with members of the committee. In addition, written statements by anyone related to today's briefing can be submitted. We welcome them. They need to be submitted by August 17, 2026. And they can be submitted at the URL listed on the screen for inclusion in the public record. And this link will be emailed to attendees as well. With that, Evelyn, I think we're ready to move on to our guests. Am I right about that?
Yes, Chair.
Okay, very good. Well, today we are delighted and indeed honored to hear from two distinguished presenters, Nadine Strawson and Ismail Royer. Nadine Strawson is a very distinguished former president of the American Civil Liberties Union. She is professor emerita at New York Law School, a senior fellow at FIRE, the Foundation for Individual Rights and Expression, and one of our nation's leading civil liberties advocates. Nadine, my dear old friend, you have the floor.
Thank you so much, Robbie, and thanks to everybody else who is involved in this very, very important work. It's truly my honor to be able to participate. I was invited specifically to address the connection between civil liberties, in particular free speech, and anti-Semitism. And that is a topic on which I have focused throughout my now decades-long career, having always been equally committed to fundamental rights of equality of opportunity and freedom of speech. I have resisted the claims by many for many years that somehow we have to choose between the two. Based on my experience, based on my analysis, I think that nothing is further from the truth, that we cannot have meaningful equality. We cannot effectively counter any form of hatred or discrimination, including anti-Semitism, without the most robust free speech. I discussed these topics in a 2018 book whose title really says it all, Hate, Why We Should Resist It with Free Speech, Not Censorship. And I'm very proud that my longstanding friend and colleague, Robbie George, was one of the many ideologically diverse experts who kindly endorsed that book. I will apply these general lessons to the specific concern of anti-Semitism, which is of particular personal relevance to me as a Jew who is the daughter of a Holocaust survivor, but I believe to the best of my ability that I am equally committed to anti-discrimination on the basis of any identity factor. The points that I want to make turn out to be 8. I numbered them this morning. Usually we think of 10 points or a dozen points. The only significance to the number 8 in this context that I thought of is, well, there are 8 days of Hanukkah, so that's perfect for the theme of protecting Jews against anti-Semitism. So point number 1, when it comes to free speech as well as other civil liberties, anti-Semitism should be treated the same as any other form of identity-based discrimination, subject to the same constitutional principles and the same other legal and moral principles. And I think one of the problems that we've seen on campuses is that there has been a double standard in how campuses respond to anti-Semitism in contrast with other forms of discrimination. So from now on, I'm going to focus on anti-Semitism as you've asked, but please continue to bear in mind that these are general principles that apply to, anti-Palestinian discrimination, anti-LGBTQ, you name it. Okay, point number 2. Most fundamentally, discriminatory conduct, I want to reemphasize that, conduct should be punished, but constitutionally protected expression should not be punished. Regarding constitutionally protected expression, the Supreme Court has repeatedly held that what it calls the bedrock principle underlying freedom of speech is viewpoint neutrality or content neutrality. Expression may never be punished solely because of disapproval, even loathing of its viewpoint, its content, its message, its ideas. No matter how hateful that expression is, no matter how hated that viewpoint is, that is never alone a justification for government repression. And this is true despite the fact that such speech can well cause emotional and psychic harm. The Supreme Court put this very well in a 2011 decision involving hate speech against just about everybody under the sun, in a decision that typically, as is typical for these cases, was supported by almost every single justice on the Supreme Court. There was only one dissenter, so across broad ideological spectrum, here's what the court said. Speech is powerful. It can stir people to action. move them to tears of both joy and sorrow, and as it did here, inflict great pain. We cannot react to that pain by punishing the speaker. As a nation, we have chosen a different course to protect even hurtful speech on public issues to ensure that we do not stifle public debate. Point 3. While government should not punish constitutionally protected anti-Semitic expression, government should punish anti-Semitic expression that is not constitutionally protected. Anti-Semitic expression is not constitutionally protected when we go beyond its viewpoint alone and consider the speech in its overall factual context. If in all the facts and circumstances, the speech directly causes or imminently threatens specific harms, such as violence, then it can and should be punished. The Supreme Court has recognized several of these contextually based contexts in which speech can and should be punished that go beyond its message. One example that sadly is very pertinent on campuses is what the court has called true threats, the adjective true to underscore that it's a legal concept very specifically defined beyond the looser way we use the word threat in everyday speech. The speaker has to be directly addressing either one individual or a small group of individuals, targeting them intentionally or recklessly, instilling on the part of the targeted individuals a reasonable fear. That is an objective fear. So we're not just talking about subjective, thin-skinned reactions, a reasonable fear that they will be subject to violence or other physical harm. In that case, the speech, far from being constitutionally protected, actually is undermining the free speech rights of the targeted individuals, as well as their other rights, including, basic human safety and freedom of movement. Point number 4. Unfortunately, there have been many accounts of situations where government officials, including public university officials, have not punished constitutionally unprotected anti-Semitic expression, including true threats. Worse yet, there have been reports of situations where officials have not punished even violent anti-Semitic conduct, for example, assaults. 5. Also, unfortunately, there have been situations where government officials, including public university officials, have punished constitutionally protected anti-Semitic expression. In particular, they have punished expression solely because of its allegedly discriminatory viewpoints and the associated emotional or psychic harm that such viewpoints might cause. Here, the very important federal anti-discrimination law, Title VI of the 1964 Civil Rights Act, has in too many situations been overly broadly misinterpreted to apply to expression that causes hurt feelings, psychic injury. I don't mean at all to diminish the significance of those harms, but as I've explained, that is not a constitutionally acceptable basis for suppressing speech. Point 6, regardless of how the concept of anti-Semitism is defined, no expression should be punished solely because it is considered to be anti-Semitic, any more than any expression should be punished solely because it conveys any other kind of discriminatory or perceivedly discriminatory viewpoint. Point 7, referring to a specific definition of anti-Semitism that has a lot of currency now, the International Holocaust Remembrance Alliance, or so-called IRA, definition of anti-Semitism was adopted not to form the basis of speech codes punishing expression solely based on anti-Semitic views, but rather for an entirely different, non-punitive, non-censorial purpose, namely to guide surveys about the extent of anti-Semitism. This is a point that has been made repeatedly and publicly, including in congressional testimony by the principal author of that definition, Ken Stern, who for more than 20 years was the head of combating anti-Semitism at the American Jewish Committee. And finally, point 8, and the oil is still burning, as a strategy for countering anti-Semitism, censoring constitutionally protected anti-Semitic expression is at best ineffective and at worst counterproductive. This was a conclusion that I discussed at great length about all kinds of discriminatory or so-called hate speech in my book. Now, to be sure, as I noted earlier, government should consistently punish anti-Semitic conduct. It should consistently punish constitutionally unprotected anti-Semitic speech. But in contrast, anti-Semitic attitudes are more effectively countered with non-punitive, non-censorial strategies, including education, information, and training. And who is better equipped to do that than our nation's campuses? Thank you so much.
Just a minute left, Nadine.
I won't use it because I'm going to say I'm happy to use the available minute to have more time to engage in discussion with all of the distinguished committee members.
Thank you, Nadine. Thank you. Thanks especially for highlighting the complexity of the issues that we're facing. Very good. Next. We're delighted to welcome another dear old friend of mine, Ismail Royer. Ismail is the director of the Islam and Religious Freedom Action Team at the Religious Freedom Institute. Ismail has for many years been a leader in the Muslim community here in the United States, whose special expertise and concern and activities have had to do with religious freedom and, of course, with religious expression. Ismail, you have the floor.
Thank you, Robbie, and I appreciate everyone for coming today. So I wanted to address the question of the connection between law and virtue, or the virtue of civic friendship. This panel today is discussing or focusing on the relationship or the question of whether creating or adoption by the government of a specific definition of anti-Semitism would have implications on civil liberties. But I wanted to talk about how, in fact, what we need to be aiming for, and while this is an incredibly important subject, to contextualize this discussion, we should talk about how civic friendship goes beyond the letter of the law. And I will explain how this context is very, very important for this broader examination that the commission is doing here. Aristotle said on the virtue of friendship, he said, "Friendship seems to hold states together, and lawmakers seem to care more for it than justice. And when men are friends, they have no need of justice. And when they are just, they need friendship as well. And the truest form of justice is thought to be a friendly quality." So what friendship means, the scholars of both Aristotle explained and also the scholars of both Judaism and Islam explained, is that it means wanting for others what you want for yourself, seeing the good of others and one's own good. And as Aristotle explains, when you do that, you do not need justice. Justice is there and the law is there so that it can define the outer limits of behavior, that line that you can walk right up to and be safe from civil or criminal consequences. But when you cross that line, then you are subject to those consequences. But just because you can say something or you can do something legally, or you can walk right up on that boundary line and say something or do something, doesn't mean that you should do that, and doesn't mean that it is wise or good, or doesn't mean that all of that contributes to the common good. Now, in Judaism, of course, I am not an expert in Judaism, but it goes without saying that the foundation of of wanting for others what you want for yourself is found in the Torah and in the Talmud, and in the admonition that you should want for others and love for others what you love for yourself, or love others as you love yourself, as it's found in numerous iterations in both the Torah and in the Talmud. And there's the concept of chesed, overflowing kindness, or in a way, as some scholars described as generosity in a way, which is going beyond the letter of the law, as Maimonides described. Going beyond the letter of the law, going beyond, for example, what is required in, for example, in giving charity, which is required by the law, to go beyond that, to do what is virtuous, and that is where the virtue consists, in doing what is more than what is required by the law. And in Islam, of course, we likewise have that statement, that principle as articulated by the Prophet, to love for others what you love for yourself, or love for your brother what you love for yourself. And our commentators made the point that this is more than just your brother in religion, your brother in Islam. It includes your brother in humanity and wanting good for them. And I'll quote something from Raghib al-Isfahani, who was a classical scholar. He said, one of the causes of order in the affairs of people is love, and then justice. And here he's using love as a synonym for friendship. For if people love one another and work together with love, they have no need for justice. And thus it is said, justice is the substitute of love when love is absent. And I would bring that around to our discussion today, because what we are looking for here is what law, essentially, what statute could be or ordinance could be adopted by the government in order to create justice. But we need that, and that is important. And I'm not going to endorse any particular definition of anti-Semitism here, beyond to note that it is certainly conceivable that there are definitions of anti-Semitism or discrimination against anyone that could have very significant civil liberties implications. But I am speaking here as a Muslim leader, and I'm speaking not only on behalf of the Muslim community, but also to a large extent to the Muslim community, who is also one of my audiences here. And so what I want to acknowledge, and it's very important to acknowledge this, that there is genuine anti-Semitism present in the Muslim community, both in America and in the Muslim majority countries. And a lot of that is, to a large extent, a modern import, translated European texts, protocols of the elders of Zion and other slanders on the Jewish people, Soviet era propaganda, rather than an Islamic inheritance. And that is not to deny, of course, that there has been, people have used passages from Islam in order to, from Islamic scriptures, from scholars, in order to justify anti-Semitism. But such people are cherry picking and attempting to map the scripture and religious justification onto something that is a contingent historical development within the Muslim community that we have to fight against. And unfortunately, I was looking for some documents or documentation, historical documentation, as to try to pinpoint where I could find the beginnings of what I perceive to be an unfortunate state of enmity and between the American Muslim and American Jewish communities. And I found documents going back to the 70s where representatives I was thinking this would be like the early 90s with the Oslo Accords, as those who are familiar with the contemporary history know that there began to be a great deal of animosity there, especially among certain factions within the Muslim community. But in fact, I found, going back to the 70s, documents demonstrating that there were among our American Muslim leaders, some very regrettable and shameful, in fact, statements, including one report I found from the from a now defunct organization to the United Nations on a conference on the question of Palestine that was advocating for Palestinian rights, but in fact taking the approach to talk about how Jews in America are American Jewish organizations are trying to undermine the Muslims in America, and in fact quoting anti-Semitic literature like Henry Ford's screeds and so on. And so unfortunately, we find that there has been among advocacy for the Palestinian, for justice for the Palestinian people, there has been combined with that these unfortunate tendencies. So I wanted to counter that by pointing out right now that that there are foundations, strong theological and historical foundations for a civic friendship. The Prophet, for example, Prophet Muhammad came to a group of Jews in Medina and urged them to help in the defense of the town against an attack by polytheists. And he said to them, "Verily, we have come to you for good. Verily, we are people of the book, and you are people of the book, and it is upon the people of the book to give aid to the people of the book." And then also in the Constitution of Medina, or the Agreement of Medina, which the Prophet Muhammad established for the coexistence, a compact, a civil compact between the Muslims and the people and the Jews in the town of Medina. He said the Jews are one community with the believers, and to the Jews is their religion, and to the Muslims is their religion. And so that is not to deny very problematic periods in the 1400-year history between a relationship between Muslims and Jews, or the current ones, or that there are people who cite scripture and canon to justify animosity towards Jews, but it is to recognize that that has to be contextualized, and that those
2 minutes, Ismail.
Thank you. And
2
those
minutes.
cannot be, yeah, thank you. And those cannot be cherry picked. So to end here, I'm going to say that what then do I mean by establishing civic friendship? It is my contention that American Muslims and American Jews, these two communities, although there have been, on an individual level, an organizational level, there's a great deal of work that has been done together and dialogue and so on. We need something that goes beyond that, and we need to establish a civic friendship to where we communities, and this might sound naive, but we communities have to work together, support one another, love one another in a civic love, in a civic friendship. And what does that look like? It means, number one, supporting one another when it comes to rights, defending one another when it comes to establishing our belongingness and our being part of America. We have to recognize as Muslims the reality of Jewish suffering and persecution in modern times. We have to recognize that for many Jews, that the Holy Land, the state of Israel, is central to their identity, even if we don't think that it should be, or we don't think that it is, that it really is. We have to recognize that that is what it means to be a Jew for many people. And so therefore, so much of American Muslim advocacy has been perceived as anti-Semitic by many American Jews. And I could explain some of these if I had more time, but there are things that we have to consider out of bounds for our discourse, political discourse, in our legitimate advocacy for the rights of the Palestinian people, and for our religious interests in Jerusalem as the third holiest city in Islam. And so we have to eschew, and we have to avoid those anti-Semitic tropes, and we have to do some very brutal and honest self-analysis to understand why and how is it that our actions have been perceived, and have in fact been in many cases, anti-Semitic, in order to move beyond that and to create a true civic friendship and contribute to the healing of America instead of the growing polarization, which needs to be a concern of everyone.
Thank you, Ismail. Thank you. Well, it's time now to go to the discussion with the committee members. I will go last. I'll begin by recognizing our Vice Chair, Miranda Jane Sapphire. Miranda Jane, you can have the floor.
I don't think I have any pressing questions at this time, Robbie. So I could yield my time back.
All right, time is yielded back by our Vice Chair, Daniel DiMartino.
Sure. Thank you, Chair. Nadine, one question. So I love what you said, but I guess then the question is, if anti-Semitic discrimination is like any other form of discrimination, then given its rise recently in the United States, or how prominent it has become, what is the role of government, right, in fighting that? Because in the 1960s, the role of government fighting discrimination against Blacks was to pass the Civil Rights Act, right? So what would be the role of government within the legal framework that we already have? Because we already have the Civil Rights Act, which, as you said, includes Jewish as a protected class.
Thank you so much for that excellent question, Daniel. And as far as I'm concerned, we have all of the legal tools that we need, as you rightly point out. But to have a law on the books does not translate into the law actually being enforced and turned into a reality. Let's start with the First Amendment itself. It has been on the books since 1791, as you well know, and yet until the second half of the 20th century, it did not provide any meaningful protection against suppression of speech solely because the government disapproved of its viewpoint, not to mention the Equal Protection Clause in the 14th Amendment and so on. So what we have seen on many campuses is either a failure to enforce or an insufficient or an inconsistent enforcement of not only anti-discrimination norms, but also enforcing the limits on free speech. And by the way, we're talking, failure to enforce principles that allow, and indeed I would say require, unprotected speech such as threats and harassment and intimidation. Those should be punished in order not only to combat anti-Semitism, but also to allow free speech on the part of the intimidated individuals to go forward. Other important legal protections are just the basic common law of torts. We have seen on some campuses actual assaults and trespasses with anti-Semitic motive and impact going unprotected. So I think we don't need more legal norms. We need more knowledge and information and the ability and will to enforce them. Beyond that, I do want to, if I may just underscore Ismail's really important point, that legal protection is the bare minimum. It's necessary but not sufficient to bring about the inclusive and equal goals that
Let me get in another question so that I don't get called out on time.
Sorry.
I wanted to ask something to Ismail too.
have a minute.
Just first, that I really liked what you said about law and virtue and civic friendship. That was very valuable. What I would ask you is, do you think that given that there is a relationship between the law and virtue, and the law can be an educator in a way too, does defining anti-Semitism differently, or we're talking here, writing a report about implementing a definition, right? Do you think therefore that would be playing a role in teaching virtue?
I do think so. I in fact endorse adopting a definition. I am very cognizant of the fact that there are civil liberties concerns when that constrains too much or encroaches too much on legitimate, legal speech. I just wanted to emphasize that while that is a goal and that is legitimate, we have to make sure that we don't just try to walk fine lines, And that being said, I also endorse things like measures like, for example, and Nadine, may disagree with me here, but buffer zones around houses of worship and so on, because I believe that those do actually violate civil rights. And so there are things that can be done that are perhaps a little bit more stringent than current law.
So
allows.
you think you support buffer zones around houses of worship? Okay.
I do because I think that certainly a virtuous person would not disrupt a synagogue or a mosque or a church.
Now,
But
how would
the
that be
law-
different? How would that be different from current laws against, say, harassment? You can't say protest all day with loud noise in front of somebody's house, for example.
I'm
Yeah.
going to give a minute of the time that our vice chair
okay.
yielded to Ismail to answer that important question. Go ahead, Ismail.
Thank you. Well, I would argue that the First Amendment is obviously the broad umbrella here and the broad principle, and that government legitimately passes laws that fill in the gaps or instantiate those principles. And I believe that unless someone convinces me differently, and I'm open to that, I believe that buffer zones around houses of worship legitimately protect rights that are aimed at by the Constitution. So even though the Constitution binds government, it doesn't bind private citizens. That being said, the Constitution does aim at protecting civil liberties, and I think that a buffer zone is a legitimate exercise of the government and the protection of the unalienable rights of human beings.
Good.
Thank you, Chair.
very much. Kevin Jackson.
Yes, thank you. I had a question for Nadine. On your, I guess it was your fourth point, where you were talking about colleges, not punishing even violent anti-Semitic conduct while then protecting, even, punishing protected speech. I was just wondering, do you know, is this especially a problem, say, in New Jersey, or in certain areas, of the nation? That's one part of it. The other is, I'm just curious, why does this happen? I mean, you mentioned Title VI. Is it that law needs to be changed, or is it that it's fine as it stands? It just administrators, do they need to be educated better as to its proper interpretation? Those are some of the things I wanted to see if you could opine a little bit further on them, especially as regards New Jersey, if possible.
Thank you so much, Kevin. As I hope the chair realized when he invited me, I am not an expert on the factual situation in New Jersey. So with apologies, I'm going to have to deflect that question. I do follow cases around the nation that happen to receive attention mostly because they go to court, but I can't from that infer what the situation is in any particular state. The general problems that I've described have not followed any geographic pattern. They pretty much occurred very pervasively on campuses all over the country. And that leads to the second question, which is, why do we have these problems? The law as written and as interpreted by the United States Supreme Court, using Title VI as the key example here, is fine as far as I'm concerned. The problem is that too many government officials, including state university officials, are, number one, ignorant as to exactly what the legal definition of punishable discrimination under Title VI is, or if they're aware of it, they don't enforce it consistently. But I think the main problem has to do with information, with actions, not with legal guidelines. To that extent, my comments very much overlap with Ismail, who is also saying law is the least of our problems here. It really has to do with culture, with understanding, and, with creating norms of enforcing the law as a minimum, but also going beyond that. Since you give me this opportunity, Kevin, I want to say that the problem with the enforcement of Title VI is that it has been over enforced on many campuses and by federal and state officials as extending to any anti-Semitic or other discriminatory expression that makes somebody feel uncomfortable. And the Supreme Court, however, in the one case in which it has defined the concept of hostile environment harassment, that's the concept that's embodied in Title VI, has given a very appropriately narrow and specific definition that says that in order to be punished under Title VI as hostile environment harassment, the expression has to be objectively offensive, so not that somebody subjectively has their feelings hurt, and so severe and so pervasive that it effectively denies equal educational opportunities. That is a much narrower definition than the comparable definition of hostile environment harassment in employment, because the court has correctly recognized that we want to overprotect free speech on campus more than we do in other societal contexts.
That's brilliant. Thank you so much for all those really insightful comments. And when you mentioned that employment aspect, it reminds me, like I'm a professor at a New York university at Fordham, and we have to take, as employees, we take all kinds of these online training programs. And I'm not sure who puts those things together, but I'm a little bit skeptical of their wisdom and accuracy sometimes. So,
Thank you. Healthy
Thank you.
skepticism
Thank
is
you,
always
Kevin.
good.
Thank you, Kevin. Next, Erica.
Yes, my question is for Nadine. Nadine, do you have any best practices that you could share from other jurisdictions, either, other states or cities, in terms of how perhaps there was an increase in just harassment and threats, right? Especially in the public, and any kind of best practices you've seen for controlling these situations?
Well, again, Erica, with apologies, I am not an expert on the factual situation of, how many incidents are occurring. I'm much more focusing on policy. And here I hope I can be helpful by saying I am very aware of multiple campuses that have adopted a range of policies and practices that surmount the problems that I've been describing. Number one, making sure that all members of the campus community actually understand the distinctions that we've been specifying between unprotected conduct, unprotected expression, and protected expression, making sure that everybody on campus is aware of those concepts and committed to the equal enforcement of them, and changing the culture of the campus. So this again ties in with Ismail's point, so that we have a culture of civility that, is not just grudgingly adhering to the protections of free speech, but welcoming the opportunity to engage in civil discourse. So if you look at websites of organizations such as the Heterodox Academy or FIRE, the Foundation for Individual Rights and Expression, you will find many examples of these positive campus initiatives, which start with the policy, which incorporate constitutional principles, including on private campuses. They do that voluntarily, but go way beyond that to orientation information and enforcement information and training, so that the defense and the exercise of free speech becomes habits of mind and treasured features of the educational experience.
Back over to you, Erica.
Thank you. Yeah, if I may ask the same question of Ishmael, and nice to see you again, by the way. I know it's been a little while.
Thank you.
Yeah, so just same question in terms of your experience and your work. Are there any best practices that would solve some of the challenges we've been discussing?
Would that be best practices by university administrators?
Yes, or in this case, right? I mean, that could be state or local government as well. Any kind of, formal action.
Yeah, it's hard because I think that when it comes to students, we all know that unfortunately many of them are just very unreasonable, and I say this with love of them as human beings, but but I think that we have to try to foster dialogue and friendship. It happened to me that I personally, my experience, I was on behalf of a pro-Palestinian organization about 10 years ago, filming a pro-Palestinian protest, and the pro-Palestinian protesters were on one side of the street and while the pro-Israel folks were on the other side. And I was going back and forth just filming. And there were police blocking between them. But because I'm filming, I could go back and forth. And I kind of started to realize that I was hearing reasonable things and understanding people on this side. I was understanding people on that side. And that was a real wake-up call to me, I think, when I was younger. And I feel like something similar, we could foster some kind of discussion as to like, put yourself in the shoes of these other people to see if you can understand where they're coming from. And when you do that, you're not necessarily going to change your own mind, but you're certainly not going to demonize or you will tend to demonize people less, I think.
Thank you.
Erica, you have a few more seconds.
I think I will yield my time
Very
back.
good. Thank you, Erica. I'll give Victoria a second here to reset the clock, and we will then move to our secretary, to John Lundgren.
So I have a question for Nadine and a question for Ismail. Let me start with Nadine. So thank you for your very clear presentation of the issues here. And I think one of the spots that's hard for me, and I think hard for everybody, is, as you pointed out, Title VI. And the boundaries between a hostile work environment or hostile educational environment on the one hand, and constitutionally protected speech on the other. So I'm thinking in terms of a kind of grid where we have a sort of row for faculty and students, and then a row for staff. And imagine the not so hypothetical possibility that there's a mass demonstration on campus celebrating a massacre in the Gaza massacre. And my firsthand recollection is that some of our staff were very upset to have people, celebrating that on campus. So if we're thinking about who's protected under Title VI, there are protections for faculty and students, and then there are protections for staff. And then in terms of who's being threatened, if it's a demonstration about a massacre involving Israelis, the sort of narrowest category would be Israelis. A wider category would encompass all Jews. And a wider category still would encompass anyone who remembers the Holocaust and sees this and realizes what a potential threat it is. Where would you, in which of those cells would you say that the Title VI conditions are crossed for imminence of threat, and in which are they not?
Oh, John, so very nice to see you. Another longtime colleague. Excellent question. And you give me the opportunity to talk about just lay out what the definition that the Supreme Court has given of hostile environment harassment, which is sometimes called discriminatory harassment, which would cross the Title VI threshold. It's not as strict as the definition for students, but in the employment context, it is that it has to be sufficiently severe or pervasive to alter the conditions of the victim's employment and to create an abusive working environment. So it is still very strict. And the Supreme Court, as well as other federal courts, have said that the mere fact that offensive or perceivedly offensive or insulting language is used is not enough. The only cases I'm aware of in which expression has been held to be sufficient to satisfy even the lower standard, the less demanding standard for employees or staff members, has been when a constellation of factors occur. And these are always very fact specific. But the constellation of factors has been a supervisor with authority over an employee or a staff member directly targeting that person with a racist slur has been the cases that have come to court, and doing so in front of other employees to create humiliation. So these are not the ordinary situations that we're dealing with on campus, which generally involve shouting slogans or making general statements not targeted at their individuals. Oh, I'm not hearing you, John.
John, you
Sorry.
need to unmute.
Sorry, just to follow up on that, and it's not exactly about anti-Semitism, but I think it could easily boil over to that. Suppose that a hypothetical student orientation, somebody from the Dean of Undergraduate Studies was to address a room full of students and demand that the students from privileged backgrounds stand up to be identified. Would that meet the sort of the supervisor direct targeting in front of other employees criteria, right? If it was based on someone's religious status instead of quote unquote privilege, would that trigger the threshold?
Well, John, my initial reaction, such terrible pedagogy that I think that person could be fired for incompetence. We don't even need to get to a civil rights violation, right? Sometimes we just have to use common sense and remember that there are much more basic legal protections that pertain to everybody. You don't have to be a member of a so-called protected category. You are an individual human being who is entitled to be taught by people who are not using alienating, off-putting, stigmatizing tactics.
Thank you, John. Nadine, I'm having to restrain myself from saying amen to that last comment, but you didn't hear me say that. Okay, so thank you, John. And now let me see if Chanel has joined us. Chanel, have you joined? Chanel would be next on the list. If not, it is Glenn's turn. Glenn Ricketts.
Yes, thanks to both of our guests. It's been a very lively and informative discussion. I favor free speech and I favor civic virtue, but I wonder how you do both of them, because free speech requires me to protect some very unvirtuous people. For example, I am in agreement with the Supreme Court's decision in the Brandenburg case, for example. This is always the ultimate test of freedom of speech or other kinds of things. We have to protect the free speech of Nazis. There's a place called hell because that's the only place you can put people like Nazis after they die. So they really strengthened my own religious faith. But it's a dilemma, because civic virtue requires self-restraint that people don't always exercise. Free speech, it allows me to say that Donald Trump is a dunce, but it also allows me to say that Adolf Hitler was the greatest person who ever lived. And I got to know if both of you could address that, if you wouldn't mind.
Glenn,
Ismail, would you like to go first? Or Nadine, you can go first.
Sure. Sorry, no.
Yeah, I think that when it comes to the protections of the First Amendment and so on, I think we are our founders wanted to create a polity in which we could try to persuade Nazis that they were on the wrong path, while at the same time not allowing, not giving the government rein to lock them up if they said the wrong opinion. So I think, of course, the the nub here is like where do you draw that line between actual harassment? And I think that that's tough. So, but we do want to be careful. Kind of an implication of what I'm saying here. Really, I sounded like in a way that I'm kind of ducking the question, but I'm kind of not, because what I am saying is that we want to be careful not to criminalize incivility. You know, we don't want to criminalize mere unvirtuous behavior or unvirtuous speech, while at the same time we absolutely want to be cognizant of the fact that this sort of anti-Semitism even being expressed as an opinion out there, it may not get you locked up, it may not get you civil consequences, but it does contribute to the frankly, I mean, the unraveling of our society, and it can end up in things much worse than being, you know, going to jail because you express an opinion that someone doesn't like. So we all have an interest really in preserving the American social compact, because it underlies the laws that protect our rights. You know, so it's just not wise to go out, and we have to persuade others. It's just not wise to go out and say whatever's on your mind at any given time. You know, so.
I don't see, as I tried to indicate in my opening remarks, I truly don't see a conflict, for the reason that to suppress somebody's hateful speech is not an effective way to dissuade them from having hateful ideas. That, you know, criminalizing, even cancel culture, shaming, shunning, ostracizing does not change people's minds. And because my overall concern is with reducing hatred and discrimination, I have done very serious research into the techniques that do work, and they all deal with not even persuasion, but exposing the person with hateful ideas to questions, and getting them to question their own ideas, and to engage in what they call redeeming themselves. They often use very religious language. There are a lot of TED Talks and memoirs that are done by former, even leaders of hateful organizations, that have been persuaded, not through treating them as criminals or exiling them from polite society, but respecting their humanity, not respecting their ideas. There are many, many examples. There are organizations now of former hate mongers who are now dedicating the rest of their lives to these kinds of more speech, education, compassionate, and empathetic outreaches to get them to change their own minds. One example is an organization called Life After Hate, which is based in Chicago.
Thank you, Nadine, and thank you, Glenn. It's now my turn, and I'd like to return to a topic that Ismail brought up. It's one of the thorniest topics for me when it comes to time, place, and manner regulations of speech. And these types of regulations, I think, are very important in the question of how we should go about combating anti-Semitism. Nadine, Ismail shared with us his view about buffer zones around houses of worship. I wonder if you could share your thoughts. I'm sure you've wrestled with this as well. What is your thinking about those buffer zones as a way of balancing free exercise and free speech, civil libertarian concerns?
Thank you so much. You see, I wrote down buffer zones. I hope I have a chance to address that. So thank you.
There you go.
Provided the First Amendment framework, Robbie, that these regulations are they must be, to be permissible, they must be viewpoint neutral, content neutral. It's not just anti-Semitic speech, but it's any speech that will disrupt function of that particular place. And the law at the Supreme Court level mostly has been created in the context of medical facilities where abortions are performed, but it's exactly the same principles. As long as there is a content and viewpoint neutral restriction on not the message, but on the time, place, or manner of the message, that's point number one. Then the additional standards are, in addition to content and viewpoint neutrality, that it has to be reasonable and that is, appropriately tailored to deal with the potential disruption. And finally, that there have to be ample alternative channels for conveying the particular message. It's a much more forgiving standard than the almost automatic unconstitutionality of viewpoint neutral or viewpoint-based restrictions, but it's still a burden of proof on the government. And it's very fact specific. If you read the Supreme Court decisions, Antonin Scalia, once said these read more like interior decoration guidelines because, maybe 8 feet is appropriate, but 10 feet is too far away and 6 feet is too close. But it's basically making a determination of what is reasonable under the circumstances to allow the message to be expressed in a place that is particularly relevant for that message to be conveyed, right? If you're opposed to abortion, you want to target people who are using clinics where abortions are performed. If you have a message that's targeted toward a Jewish audience or an audience that's particularly concerned with Israel, you want to deliver the message there, but you must do so in a way that does not undermine the prime purpose of that venue, which in this case is religious worship. And by the way, the free exercise clause doesn't really add any extra protection above and beyond what the free speech clause would appropriately protect.
Thank you, Nadine. Ismail, if I may turn to you, I want to begin by commending you for your very frank acknowledgement of the reality of anti-Semitism in the Muslim community, which of course you serve so capably, nobly. As you know, I myself am Catholic, and we in the Catholic community, our bishops, our leaders, for example, have had to acknowledge the resurgence of anti-Semitism in the Catholic community, and we're finding it especially among young men. We're going to be hearing some testimony at a future briefing from religious leaders, including Catholics, on this subject. Now, the Catholic bishops have been taking concrete steps. They put out a very clear statement, a video condemning anti-Semitism in no uncertain terms, no equivocation. They added a section to the readings at Catholic masses during Holy Week, which was a week when some of the New Testament scriptures have been interpreted historically by some people as justifying anti-Semitism, and the bishops included with the readings a warning that you're not to do this, that these are not meant to blame Jews for the death of Christ, and so forth. Now, of course, the Catholic Church, being hierarchical, can do that. The Muslim community being more like the Jewish and Protestant communities with authority dispersed, it's harder. But can you think of any examples of ways in which imams or other Muslim leaders can help to combat anti-Semitism within their communities?
Well,
I'm going to give myself an extra minute of our vice chair's time so that you can answer.
Oh, thank you. Well, one thing I can say is that there's a lot of the internal dynamics are difficult because a couple days ago, I actually had a meeting with some of the top leaders of the American Palestinian organizations, and I explained to them kind of what I'm talking about here. And they themselves, acknowledged that they were very uncomfortable with a lot of the things that were being done and said on campuses and in demonstrations. But they said that they actually had tried to impose, limits and guidelines and against what was being done, and that a lot of the young people actually called them sellouts for doing that. So.
Terrible.
So yes, that's kind of what I had in mind when I was talking about unreasonable young people.
Yeah.
So I think that we have a challenge in our community on how to on how to rein this in and how to. I mean, what I admire about the Catholic response is that it has been grounded in theology. It's been, this is not who we are. This is what, the Pope has said. This is what our scripture and our teachings really are. And you're betraying that by indulging in anti-Semitism. I think that's the kind of argument that we have to make. And it takes courage. It takes a lot of courage to go against people. One other thing is that there's a reticence. This happened to me. I condemned Hamas immediately after October 7th, and I ended up having to delete a tweet doing that. I have to admit, I mean, a lack of courage on my part. Why? Because I got attacked and people sending me messages saying, hey, I hear you, but at the same time, this could end up, anything you say could justify, a harsher response from Israel. It could cost actual lives. I don't agree with that argument, but I was just like, I honestly just kind of lost my nerve. And, so I'm trying to regain that and trying to, there are a lot of people who agree with me, let's just put it that way, but we just need to network and, and try to make an influence.
Well, you've done something very brave right there in acknowledging your own weakness. We set an example for all of us, actually, Ismail. Thank you. Miranda Jane, back to you. If you've formed any questions in the meantime, you're welcome to the floor.
Thank you, Chair. I did have a question for Nadine, and you might not know these factually, and that's fine. But you had specified that there have been violent attacks rooted in anti-Semitism across the country. And I think you're referring to them recently. Would you mind just disclosing some of them? I know geography, big country, but I'm just thinking because I would just like to know.
Yeah, well, what I'm primarily thinking of, Miranda Jane, as I indicated earlier, is the information I get from the litigation that I follow. And so there have been, and some of that is lawsuits that are brought by law enforcement officials, and including federal and state agencies, and some are civil lawsuits. A major litigator here has been the Brandeis Center. And so the example that I can think of closest to home, which was documented in a legal decision, was Cooper Union, in which Jewish students were locked themselves into a library, and pro-Palestinian demonstrators were literally pounding on the walls trying to get at them. And that is an assault, that is a threat. To show how serious it was, the president of the university was in the very same building, and she had police escort her out of the building, fleeing the danger. Now, interestingly enough, in that very same decision, some of the complaints that were the basis for the lawsuit were rejected by the judge because they did not involve violent assaults or threats, but involved rather expression that was deemed to be anti-Semitic and causing psychic injury. Another example of violent or illegal assaults, again, this is just completely off the top of my head, kind of random. My own alma mater, Harvard, and I've seen videos, and I know that things can differ depending on the angle of the camera. I've seen multiple videos of a individual student who was clearly identified as Jewish by the yarmulke that he was wearing as he was trying to walk across campus, being physically accosted by a group who I think had broken off from a general pro-Palestine demonstration, and are encircling him and even physically striking him, and also shouting insults. But the overall context is the violent context, and the threatening and assaultive physical acts is what leads to the punishable nature of that conduct, not the vile expressions that they were engaging in.
Thank you for that. I appreciate it. And I know you were explaining with Title VI, and you had just explained that it's really the violent conduct that seems to cross that threshold. And I'm just
It-
thinking about that sort of psychic injury and
It
where,
could.
yeah.
Mhm.
No, I was just saying where the line is there.
Yeah, so the Supreme Court has repeatedly recognized that words do wound, right?
Yeah.
That old saying about sticks and stones may hurt my bones, but words will never hurt me is not true. Now, it is true that words won't necessarily hurt you, and we have to teach all of our students and all of ourselves to rise above the potential psychic harm that words can cause us, to not empower those who are seeking to tear us down. But basically, the Supreme Court has consistently held, and I think it's correct, that an even greater harm would be done if we give the government the necessarily subjective discretionary authority to decide which hurtful words should be punished. That kind of authority has consistently and predictably been used against criticism of the government, attempts to change the status quo, and advocacy of rights of minority groups, whether political, religious, or demographic minorities.
Thank you so much.
Thank you.
And I don't have a question for Ismail this time, but thank you so much for being here today.
Thank you.
Thank you, Miranda Jane. We have a few minutes. If members of the committee have any additional questions, just use your raised hand function and I'll be happy to recognize you. John Londergan. John, you're muted. There you go.
Ismail, I wonder if you could elaborate a little bit about how the government could help promote civic friendship. I'm on board with the idea, but
Yeah.
we're the USCCR and we're supposed to make recommendations that can be turned into government policy. And I'd love
Yeah.
your thinking about how one might do that.
Well, as someone who endorses the Catholic principle of subsidiarity, I'm suspicious of the government's ability to solve many problems. But at the same time, I feel that getting people together to work on issues of mutual concern to the common good helps get people into the same space, humanizing one another, getting to learn about one another, and seeing that we have common values, common concerns. So I think that something along the lines of maybe through the White House Faith Office or through state kind of analogs to that, getting people together to try to solve, getting religious people together to try to work on social problems, the environment, things like that. I think would housing would go a long way to getting people together. I mean, on campus, maybe administrations could, and to the extent that we're talking about the government, where, public institutes of public institutes of higher learning, could try to bring together Jewish and other students. I mean, by the way, to be clear, most of these problems are not necessarily Muslims. These people who are out here demonstrating with Hamas flags and stuff are ironically often communists or people who are not religious at all. But that being said, to bring like Muslim Students Association and Hillel together instead of trying to get each other kicked off campus, which is so ridiculous, try to find out, okay, well, what do we have in common that we can work together on? And I have an example of that. I actually did a program with Hillel and the Muslim Law Students Association at Connecticut, the University of Connecticut, on legal advocacy for the poor and so on. So I think something like that would be really neat to do.
Thank you, Ismail. Other questions from the committee? Hearing none, Victoria, I think it's time to move on to the public comment. Am I forgetting anything?
No, you can move ahead, Chair.
All right, thank you very much. Well, again, thank you, Ismail Royer and Nadine Strassen, for answering our questions so fully and completely and without any equivocation or hesitation. We appreciate that very much. Okay, so I need to introduce again the ground rules for the public comments section. Remember, members of the committee, please, that this is an opportunity for us to hear from the public. This is not a space for our engaging in discussion or responding to questions. If, however, a committee member needs to make a clarifying point in view of a question or comment from a public commenter, please raise your hand and I'll be happy to recognize you. I'll, of course, have to use my own discretion on the appropriateness of the questions. For our public commenters, you're very welcome. This is a very important part of our proceedings for our committee and more broadly for the U.S. Commission on Civil Rights. We encourage public comments. We in no way are trying to fend them off. Remember, please, though, that the USCCR, the U.S. Commission on Civil Rights, is not an enforcement agency, and our task as a committee is to send recommendations to the Commission on civil rights topics. The public comment section is intended for any members of the public to share their thoughts or experiences. Again, it's not a question and answer session. We're here to listen to you. We'll first call on anyone who registered for giving a comment in the public comment section. And if there's time after that for people who haven't registered, if you will just raise your hand on Zoom, I'll be happy to recognize you. Our public commenters have 2 minutes, and I'll give you a quick heads up as your time is running out. And please remember the basic rules here of civility. To do our work properly, we can't have people engaged in defamation or degradation or name calling or that kind of thing. If needed, it's my responsibility to intervene to redirect comments to the topic at hand if comments are made that veer from the topic, and if necessary, and I do hope and trust that it will not be necessary, I hate doing it, but it is my duty, if necessary, to mute anyone who does not stick with the rules. Let me ask our staff, our USCCR staff, if we have anyone who has registered for the call, because again, if we have registrants, they have priority in the commenting. Do we have any registered commenters?
We did have one person register, Maria Cruz Garcia. I don't see her on the list, but I would still like to call on her in case she's joining from a different line. Maria
Okay.
Cruz Garcia.
Ms. Cruz Garcia, if you are there, the floor is yours. I'm going to give you a second to respond.
And I
Not
don't believe
hearing
she's
a
on the line.
response. I'm sorry, Victoria?
No, I don't believe she's on the line, Chair.
Okay, all right. Then is there anyone who's not registered but nevertheless would like to make a comment? You're very welcome. Victoria, I am hearing no requests for the floor.
I do see a hand raised, and I apologize if I mispronounce individuals' names. Sadaf Jaffer is the first person with their hand raised.
Very good. You are recognized. Please unmute that person.
Good afternoon. Thank you so much for having me.
Certainly.
Combating anti-Semitism is a moral obligation, as is confronting anti-Palestinian racism, anti-Muslim bigotry, and all the other forms of hate. I and many others caution against adoption of IRA because silencing Palestinians, Muslims, Jews, and allies who oppose Israeli state policy does not contribute to these efforts. The IRA definition has been widely criticized by FIRE, the ACLU, legal scholars, and human rights advocates for conflating criticism of Israeli policy with anti-Semitism. This is because most of the examples in IRA relate to the state of Israel. For example, under IRA, it would be considered anti-Semitic to make statements calling Israel a racist state. There may be disagreement on this, but many people do and have the right to call the United States a racist state. IRA also considers comparing any actions of Israel to the Nazis as anti-Semitic. In December of 2024, the Israeli newspaper Haaretz quoted an IDF soldier as saying, quote, "I felt like a Nazi. It looked exactly like we were actually the Nazis and they were the Jews." Under the IRA definition, this IDF soldier would be considered anti-Semitic and Haaretz would be considered anti-Semitic. For these reasons, numerous Israeli groups, including human rights organization B'Tselem, oppose IRA. We've already seen IRA used to silence in New Jersey. In Camden County, where a pre-approved lunchtime student walkout in solidarity with the people of Gaza was canceled after county commissioners claimed that the phrases, quote, "free Gaza" and, quote, "stop bombing Gaza" are anti-Semitic based on IRA, and they even threatened to cut school funding. IRA chills the free speech of Palestinians, Arabs, Muslims, Jews, and allies who oppose Israeli state violence. Moreover, there are no legislated definitions for anti-Black, anti-immigrant, or anti-LGBTQ hate. Alternative frameworks like the New Jersey Statement address anti-Semitism without conflating the Jewish community with Israel. Rather than addressing discrimination, IRA will give legal force to this discrimination. Thank you.
Thank you very much. And Ms. Jaffer and anyone else, you remember that you're welcome to submit written testimony as well if you want to expand on anything that you have said. Victoria, do we have any other hands up? I do not see any.
Yes, I do see two other hands raised currently. The next person is Ramzi Abdallah.
Yes, sir. So Ramzi Abdallah has the floor. Please unmute Ramzi Abdallah.
Hello, thank you, esteemed members of this panel.
You are welcome. You've muted yourself, Mr. Abdullah. Please unmute and you can continue your
Okay,
comment.
can you hear me now?
Yeah. Yes, we can. Thank you.
Thank you. My name is Ramzi Abdallah. I'm the Executive Director for the New Jersey Muslim Civic Coalition. I'd like to start off by saying we must remember that we are in the United States of America and are protectors of the U.S. Constitution. After all, it is our identity as Americans, as is recognized all over the world. Furthermore, New Jersey played a pivotal role in founding this nation. The victories in Trenton, Princeton helped preserve the American Revolution, and the New Jersey Plan helped shape the Constitution built on liberty, equal representation, and individual rights. For any bill to be considered just, fair, and legally sound, it must meet a clear threshold. It must serve a legitimate public purpose, be narrowly tailored, treat people equally, provide clear standards, and fully respect constitutional rights. The proposed IRA definition being made failed to meet that threshold. While combating anti-Semitism is unquestionably a legitimate goal, critics of this bill contended that the bill risks infringing on the First Amendment protections by creating a chilling effect on free speech, free assembly, and political expression concerning the Israeli-Palestinian issue. There is also a justified cause for a case for infringement of the 14th Amendment, in that the bill's vague and subjective standards could lead to arbitrary enforcement, unequal treatment, and due process violations. The issue was never whether anti-Semitism should be opposed. It absolutely should be. The issue was whether the bill protected civil rights without compromising the constitutional freedoms of speech, due process, and equal protection that New Jersey helped establish and all the Americans are entitled to enjoy. I agree with what I heard from Ms. Nadine. The proposed IRA definition does nothing. We have laws that are on the books that are meant to protect against discrimination. The proposal and mandate of any governing body.
Can you wrap up, Mr. Abdullah? Your time is ended, but go ahead and finish your comment.
Thank you, sir. I would submit to this committee and to all committees that a mandate should be formulated in which education on how to enforce the laws on the book on the part of authorities that do enjoy that authority to actually make sure that they're carried out justly and fairly and equally for all to be able to enjoy the protections. Thank you, sir.
Thank you, Mr. Abdullah. Appreciate that very much. And let's see, do we have another commenter?
Yes, the next person with their hand raised is Gabrielle Rubenstein.
Ms. Rubenstein, please, the floor is yours. Please unmute Ms. Rubenstein.
Hi, thank you so much for taking public comment. I really appreciate it. I really appreciate all of your work on this panel. I wanted to particularly thank Ms. Nadine Strawson for everything that she said. I really, as a Jewish person who's a lifelong resident in New Jersey, really appreciate everything that she said about what we need from the state of New Jersey and our government to fight anti-Semitism. And to make sure that in doing so, we are speaking accurately about the issue and that we're not threatening anybody's civil liberties or free speech. I want to uplift something that she said and that some others have said, that the IRA definition of anti-Semitism is widely contested beyond never having been intended to be used for legislation. It's just not something that's widely accepted even within the Jewish community. the Reform and Reconstructionist movements, which make up a huge chunk of New Jersey synagogues, as well as hundreds of Jewish groups in the US, including the Progressive Israel Fund, all disavow this definition and don't want to see it used in legislation. Recently, a poll came out showing that almost half of American Jews under age 35 say that the Israeli-Palestinian conflict should be resolved by creating a single country in Israel, the West Bank, and Gaza with a government elected by both Israelis and Palestinians, according to a poll conducted by the Jewish Voter Resource Center. This functionally means that almost half of American Jews under that age of 35 are functionally anti-Zionist, and that means that any political speech that they did on behalf of that position would be criminalized by the IRA definition. So personally, I'm very concerned as a young Jewish person living in New Jersey that our government might potentially codify a definition of anti-Semitism that would functionally criminalize many Jewish people for expressing our political views in line with our Jewish values and not rooted in any sort of anti-Semitism. So thank you for listening to me for that.
Thank you, Ms. Rubenstein. Are there other hands up, Victoria?
Yes, the next person I see is Katie Schiff.
Ms. Schiff, please unmute her. The floor is yours, Ms. Schiff.
Hello.
Yes.
Hello. I am a Jewish and a non-Zionist, and I find that it's important as a non-Zionist Jew that when it comes to defining anti-Semitism, there's also needs to be a distinction between Zionism that supports this Israel versus Judaism and protecting it. As I believe it's important to understand that conflating the two does not protect Jews, as it takes away, kind of conflates them and pushes this idea of Jews automatically support the state of Israel, which is not true. There are non-Zionist Jews who also are out living in New Jersey and must also be protected while also being allowed to freely express their belief and their views. And I'd like to mention that it's important to note that like how educating and making sure that there's the difference between Zionism and Judaism is stated to all like law enforcement and those that are placing into this definition, as well as to ensure that they understand that IRA would not be there for all Jews.
Thank you very much, Ms. Schiff. Victoria, do we have other hands up?
Yes, one moment. The next hand raise I see is from Halima Twam.
Halima Twam, the floor is yours, and please unmute her.
Thank you so much, and thank you for taking the time to open up to public comments and hearing our thoughts on this issue. I am the Civic Engagement and Advocacy Manager at the Palestinian American Community Center here in New Jersey. In New Jersey, we have the third largest Arab population in the country, and I believe the first largest Palestinian, and the most impacted by the war in Gaza. We've had the most amount of family members lost here in New Jersey directly through the genocide in Gaza. And there have been, so I guess like my question is when we're discussing this, because Palestine has come up multiple times in this conversation, is what is the correct way for us to protest a synagogue that is creating, that is selling illegal land from inside their house of worship, land that is stolen from Palestinian people and then put on Airbnb after kicking out our family members. When we're being censored here in our ability to speak out against this genocide, how is it not seen as transnational repression when we are being threatened time and time again by the IRA definition as we've combated through the New Jersey legislature, and it continues to come up in these spaces in order to not allow for us to educate on the Palestinian plight. And we are for the protection of Jews. We are for the protection of all people. We work alongside many of them, but don't believe that the protection of Jews should overshadow the need for us to be able to talk about our own liberation as we
Thank you very
continue to
much,
deal
Ms.
with our own
Oh,
racism. If you just want to
yeah.
go see the comments on anything on our website, on anything that's posted that we do, the amount of Islamophobia and hate that we receive as we continue to weaponize anti-Semitism in regards to Palestine specifically, when we're speaking about Zionism, is really the issue here. Thank you.
Thank you, Ms. Twom. Other hands up?
Yes, I see a hand raised from Adam Weissman.
Yes, Mr. Weissman. Is he unmuted? There you go. Please unmute Adam Weissman. The floor is yours, Mr.
Thank
Weissman.
you. Before I begin, I have a question. If we speak today, will we be able to speak at future hearings as well? Or is there a
Yes, you
limit to
will.
one? Okay,
No,
wonderful.
yes, you will.
Thank you. Okay. My name is Adam Weissman. I am a New Jersey Jew and the great-grandson of a Holocaust victim and the great-great-nephew of a Jew killed in Belarus during the Pesach holiday, a time associated with violence against Jews incited by the blood libel. In 2002, Shulamit Adoni, former Israeli Minister of Communications, was asked by Democracy Now! Host Amy Goodman, often when there is dissent expressed in the United States against policies of the Israeli government, people here are called anti-Semitic. What is your response to that as an Israeli Jew? She replied, well, it's a trick. We always use it. When from Europe somebody is criticizing Israel, then we bring up the Holocaust. When in the United States people are criticizing Israel, then they're anti-Semitic. Efforts to pass IRA laws and buffer laws are part of a McCarthyite anti-Semitism scare manufactured by the Israel lobby, which seeks to misrepresent opposition to Israel's genocidal aggression as anti-Semitism, threatens our civil rights and civil liberties, and in particular targets Arabs, Muslims, immigrants, and pro-Palestinian Black voices. Real anti-Semitism overwhelmingly comes from the right, but the anti-Semitism scare almost exclusively focuses on fake anti-Semitism on the left and from the Arab and Muslim communities. Its goal is to help Israel complete the genocide, curtail free expression, civil rights and civil liberties in the U.S., put the right in control of or destroy institutions that produce thought and share information that challenges the right's agenda, e.g. universities, and to destroy the careers of commenters, scholars, educators, and politicians who don't walk in lockstep with the Israel lobby, and in the process scare others into obedience and silence. They don't challenge the right because this is a project of the right. ADL's response to Elon Musk's Nazi salute being a clear example, and Senator John Fetterman's recent false claim that anti-Semitism is more of a problem on the right than the left pretty much gave up the game. While anti-Semitism is an organizing tool of the extreme right in and of itself, it is not a major problem in the U.S. requiring government action. However, the potential of Zionists insisting Jews and Israel are inseparable, constantly talking about anti-Semitism, and repressing people in the name of fighting anti-Semitism may first create anti-Semitism via the Streisand effect.
Okay, thank you very much. Are there any other hands up?
I don't see any other hands raised at this time.
Okay, I'm going to give people another second to raise hands in case there is anybody who wants to speak. I don't see any. So I think that concludes our business for the day. Let me ask Victoria and Evelyn if there's anything else that needs to be accomplished in this briefing.
Chair, if you wouldn't mind before you adjourn, just naming the due date for the written testimony and the dates and times of the upcoming briefings. They're also on the slide I'm sharing now.
Okay, yes. So does everyone see it there? Written testimony can be submitted by August 17th. That's the deadline for written testimony. The next briefings will be Thursday, June 25th. That will be at 1 o'clock Eastern Time. And then again, Wednesday, July 15th, that will be at 3 o'clock in the afternoon Eastern Time. So briefings coming up June 25th, 1 p.m. Eastern, July 15th, 3 p.m. Eastern. You can learn more about the USCCR at the website that the link to which is on the screen there. Victoria, any other matters to be covered?
No other matters.
Well,
If you can please just name the time when you adjourn the meeting, and then we'll end it.
yes, it's 4:43, but I'm going to give myself just a minute to say a deep word of thanks to our presenters today, our guests, Ismail Royer and Nadine Strawson. Those comments, and especially your very candid and helpful answers to our questions, are really going to be of tremendous use to us as we go forward with our report. I hope you will submit any additional information or commentary that you have to us. That too would benefit us, and I hope that you'll be available for us to call on you again if we need you. You really are important contributors to the work of our committee, and I just cannot thank you enough.
Right back at you. Thank you so much.
Thank you.
Thank you, Robbie.
And with that, at 4:44, we are adjourned. Thank you, committee members. Thank you, Victoria and Evelyn.
Thank you, everyone. Have a wonderful evening.